Hey everybody, this is Mr. Moppin coming at you again with another APGov video. Once again, this is another video from the series focusing in on topic 3.10, taking a look at social movements and equal protection under the law. Now, previously we have looked at some of the aspects of how African Americans would use certain strategies and tactics to fight for civil rights, and then most recently we looked at how women, going back to the 19th and early 20th centuries, we're making strides in fighting for equal rights as well. Today what we're going to do is we're going to continue with a focus on women's civil rights, bringing us up to the current day. Now, before we move forward anymore, one thing that we do need to kind of understand is that when we do talk about issues dealing with gender discrimination, we have to keep in mind that the standard that is used by the court for gender discrimination in terms of whether or not it's a violation of the 14th Amendment's Equal Protection Clause is different than the standard used to determine if racial discrimination is a violation of the 14th Amendment Equal Protection Clause. If you may recall from a previous video, we talked about how there is an automatic assumption of unconstitutionality regarding any type of action that is done in the name of racial discrimination, and that's based on what's called the strict scrutiny test. With regards to gender discrimination, it is a lower standard. It's what we call a reasonableness standard. What that means is that the court allows for more discrimination based on gender than we allow for race. Now, before some of you get pretty upset and thinking, hey, are we saying that the court is by definition more sexist? You know what I mean? That's not necessarily what we're trying to say here. It's just that there is an idea that we do have more of a reasonable need for discrimination based on gender than we do based on race. For example, if you are talking about having bathrooms, public restrooms that are segregated based on race, whites-only restrooms versus restrooms for people of color, that would be a racial discrimination. Now, to have that kind of a bathroom policy would be seen as a violation of the Equal Protection Clause. It would automatically be assumed to be unconstitutional, and there is no overarching, massive, compelling state interest to segregate based on race. However, policies that segregate based on gender, or in other words, discriminate based on gender, in other words, having separate restrooms based, some for men and some for women, is seen, at least as of now, as not a violation of the Equal Protection Clause, based on a reasonableness that different genders want a certain level of privacy/safety when it comes to using a restroom. Now, there are some interesting questions that you can maybe ask regarding the continuation of the reasonable standard as we start to get into issues of gender fluidity, transsexual identification, stuff like that. But just at least in this context, with the traditional definitions of gender, that is why we have a different standard. Now, note, just because we have a reasonableness standard, it does not just come up with the idea of, well, you can just discriminate. For example, if you're going to have, different rules for a woman getting a driver's license than a man getting a driver's license, there's no reasonableness to needing that kind of discrimination. Therefore, any kind of state policy to discriminate based on gender regarding obtaining a driver's license would not be protected. It would be seen as a violation of the 14th Amendment Equal Protection Clause. So just kind of keep that in mind as we talk about some of these items. Now, that being said, as we start to get into the 1960s and 70s, especially once we start to see the publication of the Feminine Mystique and the creation of the interest group Now, we start to see some very important achievements for women's rights. And one of those, as we get into 1972, is the creation of Title IX. Now, Title IX is technically an extension of the Civil Rights Act of 1964, which we'll get to later. But note, what Title IX does is require that any educational institution that is receiving federal money, which is basically every public institution, and just about every private institution as well to some degree, receiving federal money, must provide equal educational opportunities regardless of gender. So the idea being is that, unlike in, back in the 1950s where public schools might say that, auto shop is only for male students, and home economics was only for female students. Title IX gets rid of those policies. So every class is open to every student regardless of gender, which has now opened the doors for many female students to be welcomed into areas where women had not traditionally been welcomed into, in terms of areas of study such as math and science and computer technology, medicine, engineering, all that kind of stuff. Additionally, most of you that may have heard of Title IX already probably know about Title IX because of the athletic components of Title IX. Title IX also extends into athletic opportunities within an educational setting. So, in other words, you must offer the same number of female sports as you do male sports. And note, this is most especially important at the collegiate level, where, as some of you may be aware, that for generations, we saw thousands and thousands of male students get the opportunity to go to college due to athletic scholarships covering the cost, whereas females did not have those opportunities because female scholarships didn't exist, in part because female sports didn't exist. But now that has been done away with. So now female students have just as much of an opportunity for athletic scholarships as male students do. So Title IX is a very important achievement for women's rights for sure. Now, another attempt at trying to solidify civil rights for women, though it will come up short, will be the ERA movement of the 1970s. ERA stands for the Equal Rights Amendment, and what it basically did was propose a constitutional amendment. If ratified, it would have been at the time the 27th Amendment, which would have basically just simply said that you could not discriminate on account of sex. Now, that seems like a pretty basic, straightforward thing, but this did lead to some controversy over time, at least. Initially, it was very popular. This was kind of at the height of the feminist movement of the late 60s and early 70s, and you saw a number of states ratify it pretty quickly, but then there was a conservative backlash against it, led by, for example, Phyllis Schlafly, that argued that the ERA may prove to be more problematic for women than helpful for women. Concerns such as, will ERA destroy the traditional values of chivalry? Will it take away from what had been a traditional court willingness to defer to mothers in terms of gaining parental rights in the case of divorce and things like that? And note, this conservative backlash against ERA is happening at the same time there's a conservative resurgence in America as well as we get to the late 1970s. So ERA never gets quite enough votes to be approved, but it does show where the nation's going on the idea of civil rights for women. Now, be aware, and now we've talked about these cases in previously, so I'm not going to go into much detail about this, but keep in mind that one of the areas of concern traditionally for women in terms of equal rights is dealing with reproductive issues. The idea being that women should be allowed to be able to make reproductive decisions, medical decisions over their own body, just like a man can. Now, note, when we get into some of these issues, I know it does get into some issues of morality and things like that. So, for example, if we're talking about how Roe versus Wade is seen as a victory for women's rights in terms of having the constitutional right to have an abortion, I'm not trying to say that it is good to have an abortion or that, that is, something that women should be doing per se. It's just the idea that for many women, having that option is viewed as a victory. So I want you to understand why it's viewed by many as a victory. I'm not telling you that you have to agree that it is a victory. Griswold v. Connecticut, before that, of course, having the protection to be able to purchase contraception for those seeking it. All right, now, to kind of round this out, I did want to talk about a significant area, once again, for women, and that is dealing with the workplace. Now, we mentioned previously that the Equal Pay Act of 1963 is going to be significant in that it will protect against pay discrimination based on gender. And shortly after that law is passed, we're going to see the Civil Rights Act of 1964 pass. Now, the Civil Rights Act of 64 is most famously associated with abolishing segregation and guaranteeing protection from discrimination based on hiring practices with regards to race and ethnicity. However, we cannot overlook that gender is also included in the Civil Rights Act. It's kind of an interesting story that opponents of the Civil Rights Act actually approved amendments to put that into the bill to try to kill the bill, but it actually gets passed with the amendment protecting women as well included in it. So women are also protected via the Civil Rights Act. Now, some of you might be thinking, well, if women are protected from hiring discrimination, for example, in the Civil Rights Act of 1964, why would you need the ERA? Well, keep in mind, the Civil Rights Act is a simple piece of legislation which could be overturned with a simple majority of the House and the Senate and the President's signature, whereas a constitutional amendment is much harder to overcome. So just be aware of that. So that being said, the Civil Rights Act, and then of course when we talked about a moment ago, Title IX, these are very important foundational things that say that you cannot prevent someone from being hired simply because they are a woman. That you cannot deny a woman equal pay simply because she is a woman. You cannot have these kinds of policies. You can't fire somebody just because they are a woman. So this is very important stuff. Now note, the Equal Pay Act, was a very important achievement. However, you have to read the fine print for a lot of legislation. In the Equal Pay Act, it stipulated that those that were making claims that they had been discriminated against in terms of pay, therefore being in violation of the Equal Pay Act, you would have to prove that you had been discriminated against within the first 6 months of being hired, or in terms of first 6 months of getting paid in an unequal manner. Now, note, in the private sector, rarely do people know what their coworkers are making. So you could go years and years and years and maybe an entire career without knowing what some of your coworkers are getting paid, and in reality you all might be getting paid different amounts of money. So what we saw happening is that women were finding out that they were getting discriminated against in terms of pay, but the statute of limitations to be able to file a lawsuit via the Equal Pay Act had already run out. That then brings us to the Lilly Ledbetter Act. Lilly Ledbetter is going to be the namesake of this legislation, which will now stipulate that the 180-day statute of limitations to be able to sue for pay discrimination resets after every paycheck. So in other words, it's not 6 months from your first paycheck, it's 6 months from your latest paycheck that then makes you potentially eligible to file a lawsuit claiming pay inequity via this now Lilly Ledbetter Act. So that's an important recent achievement. Lastly, of course, keep in mind that another major issue affecting women historically are issues dealing with sexual harassment. And, this has been going back a long, long time. It's not just discrimination in terms of not getting hired, but women in the workplace, being the victims of objectification, being the victims of, unwanted sexual advances and things like that. This has been a constant issue for women for generations. And note, over time we have seen more and more steps moving in that direction to address that issue, though still it has not been completely eradicated for sure. But note, one of the more recent movements in the attempt to bring attention to this issue has been the recent #MeToo movement, which has kind of sent a message that, as a woman, if you have been the victim of sexual harassment or even worse, sexual abuse, that you are not alone, that unfortunately, 1 in 4 women in their lives will be the victims of sexual abuse. That's not counting, workplace sexual harassment. And a strong willingness now, a strength, a bravery to be able to point out those that had been committing acts of sexual harassment or sexual abuse. Most notably, there's a lot of figures in Hollywood. I'm not going to mention any names specifically, but, a lot of recent figures in Hollywood, for example, have been identified as, victimizers as a result of the Me Too movement. So hopefully, we are seeing more and more of a momentum to, address some of these very important issues. So we'll leave it there for this time. We'll see you next time.